5 seconds. Start. The submission of learned counsel for the petitioner in respect of the award made on claim number 1 is that the said award has been made contrary to the contractual terms and the evidence brought on record is also to the contrary. Stop. The submission is that the learned arbitrator has acted beyond his jurisdiction and has not decided the reference as per the terms of the agreement, resulting in an unfair and unjust award. The submission of Mr. Rao is that Clause 13 of the NIT advised the tenderers to inspect and examine the site. Stop. It further provides that a tenderer shall be deemed to have full knowledge of the site, whether he inspects or not, and no extra charges consequent on any misunderstanding or otherwise shall be allowed. Stop para. Learned counsel also invited my attention to the order passed by the learned trial judge allowing the application filed by the respondent for restitution of conjugal rights and dismissing the Hindu marriage petition filed by the appellant inter alia, praying for annulment of marriage and for divorce. Stop. He submits that the respondent had filed a false complaint against the appellant and his family members, due to which the appellant and his family members were arrested and were subsequently acquitted by an order dated 5th September 2005. Stop. The learned 4th Joint Judicial Magistrate, First Class Karnal, has found that the prosecution had failed to prove any offences alleged to have been committed by the appellant and his family members. Stop. Such action on the part of the respondent in filing such false and frivolous complaint and getting the appellant and his family members arrested amounted to an act of cruelty by the respondent upon the appellant. Stop. It is submitted that the Hindu marriage petition thus filed by the respondent wife under section 9 of the Hindu Marriage Act for restitution of conjugal rights itself was not maintainable in view of the act of cruelty on the part of the respondent upon the appellant having been proved. Stop para. He submits that the order passed by the lower appellate court dismissing the appeal filed by the appellant and upholding the order passed by the learned trial judge is also patently erroneous and contrary to the law laid down by the Supreme Court and this court in catena of decisions. Stop. Learned counsel appearing for the appellant placed reliance on the judgment of this court delivered on 6th May 2010 in Family Court Appeal number 158 of 2008.